I have some breaking news that the Supreme Court just handed down a 7-2 decision that will shatter the deep state's election apparatus forever in a very big way. So today, in one of the most earth-shattering rulings in modern election history, 7 out of 2 justices have declared that candidates running for federal office now have ironclad automatic standing to sue and challenge potential fraud and irregularities in elections, which is a decision that will have nationwide impact and change the game forever. SCOTUS rules 7-2 that candidates have inherent standing to sue in federal court over election rules. Now, this 7-2 ruling comes from a case in Illinois, Bost versus Illinois State Board of Elections, where the candidate Michael Bost sued the State Board of Elections for counting ballots 14 days after Election Day. Now, this was a case that never got reviewed by the lower courts because they tossed it for lack of standing, saying that essentially you can't show injury in this case, so therefore you don't have the right to bring it. So we're tossing this for lack of standing. Now, the Supreme Court just ruled that, in fact, this candidate and every federal candidate nationwide does, in fact, have ironclad standing when it pertains to challenging elections, and this has nationwide implications. Now, let me drive my first point home that this is going to lead to a flurry of litigation. There's going to be hundreds of lawsuits in the next election cycle and every election cycle that follows, because now any federal candidate, basically for any reason, can file a pre-election lawsuit or a post-election lawsuit that can challenge voting procedures, election laws, mail-in ballot rules, the deadline by which they have to count the ballots after an election, all that stuff. They can challenge it, and now they have standing. That is absolutely going to lead to tons and tons of lawsuits from both sides in every election cycle from this point forward. And that was actually the argument by Justice Sotomayor and Jackson as to why they shouldn't rule in favor of the plaintiff. They basically said that this is going to disrupt the election process, this is going to delay the certification of elections, and therefore we should not give standing to federal candidates to challenge elections like this. That was their argument. But the other justices, the 7 that have a brain, decided that, hey, we had that situation, remember, in 2020 in Pennsylvania, where they were counting mail-in ballots like way after Election Day. Some were even postmarked after Election Day, and they still counted them. And that was blatantly unconstitutional. But what happened was the cases were dismissed for lack of standing, not based on the merits and not based on the lack of evidence. And we can't have problems like this recurring in elections. Well, up until this point, if a candidate were to file a lawsuit preemptively before the election even is conducted, saying this is a violation of state law and this has to be changed before the election, or else it's going to lead to illegal ballots being counted. Well, the courts are going to say, because the election hasn't happened yet, there's been no injury, and therefore we're not going to take up this case because you don't have standing, because you failed to show how you were injured by election procedures which haven't played out yet in an actual election. And then what would happen is we would have the election, the fraud would take place, illegal ballots are counted, and the candidate would file a lawsuit after the fact, and it would get dismissed for something called laches, which basically means you can't file the lawsuit now because it's too late. You saw that the law was being broken before the election, and you waited until afterwards to file it. So this is barred for laches. And this is what's been happening every election cycle since I've started paying attention in 2020. They get dismissed for lack of standing if you file the lawsuit before the election, and they get dismissed for laches after the election. Well, not anymore, because of the decision that was handed down by the Supreme Court today. And now the case is going to go back to the lower courts, and they're going to rule on the actual evidence and the actual merits of whether or not the state of Illinois can continue to count ballots 14 days after Election Day. This is massively encouraging. The seeds that were planted by the election integrity groups, the activists, the people that filed these lawsuits after the 2020 election, the 2022 election, these seeds are finally growing and bearing fruit years later because of a persistence, an integrity, an inability to just let the law be broken and just let it go and not fight. These people have been fighting all along, and now we're seeing these decisions being made right before one of the most important election cycles in American history. But there's actually a much, much bigger case where the RNC is bringing a case before the Supreme Court, which challenges whether or not states can legally allow mail-in absentee ballots that are postmarked by Election Day to be received and counted days after the actual Election Day. Because there's at least 12 states where the state allows ballots to be counted after Election Day, but there's actually a federal statute, U.S. Code 7 and 3, U.S. Code 1, and the argument is that it doesn't matter if ballots are postmarked before Election Day, you can't keep receiving them and counting them after the Election Day because it's clear there is a federal statute that says there is a single Election Day and all ballots must be counted by that day. So the Supreme Court's actually going to review this case. Oral arguments are set to be heard in March of this year, with a decision likely made by the summer in time to affect the 2026 midterm elections.